All right, hello and welcome to this evidence video capsule. Now in this evidence capsule, I'm looking at a very particular and tricky problem in the law of privilege. It's tough for lawyers, judges, and certainly law students to wrap their head around. Now here's what I'm focused on. It's a pretty common scenario in the law of privilege. You have communications that are going back and forth between lawyers, but also a host of experts or third parties. And there's a number of different individuals involved. The question that becomes difficult to consider is when push comes to shove and somebody wants that material after the fact, is it protected by solicitor-client or what I call legal advice privilege, litigation privilege, or none of the above? That's what I want to dig into today. So come on in and we'll have a look. So in a nutshell, this is the question that I want to address here today. I'll show you in a minute that it's very clear that communications from clients to lawyers are protected, but the real question is when you have a lawyer-client and you have a third party of some sort, when are communications from these third parties that involve clients, so perhaps their client through a third party to a lawyer, when are these protected by legal advice privilege? And as we'll see, it's a very, very difficult question for good reason. And I'll begin with a very clear caveat. I am not dealing with what is sometimes referred to as common interest privilege, which allows communications from third parties to be shared with lawyer and client and still be protected by the privilege. I'm going to assume I'm dealing, as you will see, with experts. I'm not interested in the common interest problem. That is a problem for a future video blog, also very complex, not my concern today. So this is the scenario that I am dealing with today, and I'm using an accountant as an example, but that makes no difference. You can pick any expert or really any third party whatsoever, but the most common is the expert, and as you will see, the case that actually raises this problem so directly, the redhead case that is the subject of this blog, it deals with an accountant. So I'm going to talk about it in the context of an accountant, but you can apply this analysis to any situation involving a third party. And the reason why this problem arises so often is because we tend to think of solicitor-client privilege or legal advisor's privilege, whatever you want to call it, as a continuum really between lawyer and client. And it's true that most communications that we deal with involve client-lawyer communications, and we don't have to consider the problem that I'm about to address. But just as commonly, lawyers do a lot of work with third parties, and so do clients. The more complex the transaction, the more likely it is that you have third parties, fourth parties, fifth parties, all sitting in on the communications. And the question really arises, in what situations does the privilege apply between communications that go in a more indirect fashion? So let me show you exactly what I mean about the types of communications I'm considering. So the easiest communications to deal with are the direct ones, and I'm not going to worry about these any further. And you can assume, by the way, for the purposes of this video blog, that all the other aspects of the privilege are satisfied. I'm not worried about exceptions. I'm not worried about is it for the purpose of obtaining. Let's assume that's satisfied. So direct communications are clearly privileged. Now, what we also know is that the communication between lawyer and client is an absolutely essential part of solicitor-client privilege, which I explain in my capsule on solicitor-client privilege. And what we know is that communications that are exclusively, and that's what I'm trying to describe here, between client and expert or between lawyer and expert are not covered by solicitor-client privilege. That's absolutely clear. There must be a connection between lawyer and client. So if a client hires an accountant, it doesn't matter what the purpose is. If a client hires an accountant for litigation purposes, it's either litigation privilege that covers the communication or, as we will see, nothing. Clients hire experts all the time, and if it's not for the purpose of litigation, litigation privilege doesn't apply. The same is true of a lawyer. If a lawyer hires an expert and wants to speak with them about some matter, even if it's related to a client file, that's not solicitor-client privilege. You need to be very clear about that. That's the whole doctrine of litigation privilege. When a lawyer hires an expert, that expert is covered by litigation privilege if it's for the purposes of litigation, or nothing. It is not privileged information. It's one or the other, right? But it is not solicitor-client privilege. That's very clear because solicitor-client privilege only covers communications between lawyer and client. Or does it? That's the question I'm about to examine. Because what I've just said to you is very simple in the abstract, but it becomes very complex in the context of complex transactions that do tend to involve experts. And in a sense, the idea is that these experts are actually operating as intermediaries for what is in reality a lawyer-client communication. At least that is the idea. And the courts have recognized, as I will show you, that there are situations in which that can take place for very good reasons. Again, you can have lawyer-client communications that are indirect, and that's perfectly legitimate. The most obvious example is a translator. Let's say you throw in a third party, and that third party is a translator. Well, if the client doesn't speak English and the lawyer only speaks English, the translator is essentially passing on the message from client to lawyer. And the question becomes, in what circumstances does a communication using a third party intermediary suddenly get invested with solicitor-client privilege? And just to reiterate, this happens all the time, and there's nothing sinister about it. You know, if lawyers, if you send a communication through the mail, that's protected. If you send it through the lawyer's assistant, that's protected. If you send it through your assistant to the lawyer's assistant, that's protected, because once again, the communication, the privilege, is designed to protect all communications. It doesn't matter whether they are direct or indirect. They are still protected because they are designed to further the communication and designed to further contact between the lawyer and client, which is designed to further the privilege so that you can get access to legal advice. The problem is, as I'm going to show you, is that this category of indirect communications has to be kept narrow. And the reason for that is that legal advisor's privilege is an exceptionally strong privilege. And if you broaden this idea of what kind of third parties constitute representatives, you're likely to keep a lot of information from the court. So let me just take a look and show you why it matters that we're having this discussion. And believe me, it matters a great deal. So let's just say we have a communication of this type, and I'll put it into very concrete terms using the communication that was at stake in Redhead, where the client gets the expert accountant to fill out some form of balance sheet, let's say, or put together a complex report involving a proposed financial transaction, which Revenue Canada then says is problematic, and during an audit they want to get access to the expert's information. So litigation privilege is clearly not an issue because there was no litigation. Everybody concedes that, and the only issue is whether or not it's legal advice privilege. Well, Revenue Canada wants that information, and they can't have it if it's privileged. The only privilege possible is the client's suggestion that the expert report was being prepared for the lawyer. So therefore, the expert was essentially an interpreter, right? A form of intermediary in which the expert was passing on information to the lawyer. And the problem is, as we will see, this can be utilized in a way that's somewhat sinister because obviously the client wants to keep this information privileged. It's always to their advantage to try and keep information from the other side, and they will do that by trying to say it's privileged. So why does all this matter? Well, it matters because, number one, in some circumstances you might say, imagine it was for litigation. Well, what difference does it make? Litigation privilege or legal advice privilege? Well, number one, litigation privilege, legal advice privilege is the strongest. It is the hardest to get that by, and there's also a presumption that all communications that are part of a valid chain, right, are privileged. So it's really hard to get out once it's considered to be legal advisor's privilege. And that extends to procedure as well. All the procedure involved makes it really hard to get at legal advisor communications. So the onus rests on you. It's very hard to get into exceptions. You know, even if litigation privilege is applicable, it's not nearly as strong as legal advice privilege. So again, it will always advantage the client to say that it's legal advice privilege. And of course it matters because litigation privilege might not apply, as it didn't in the Redhead case, because it was prepared for a purchase, it was prepared for a financial transaction. The legal advice which was being given, and there was some legal advice in this case, right, was essentially designed to help the client secure the transaction. So litigation privilege doesn't apply. So essentially it really matters to try and streamline the types of communications that will fall within solicitor-client privilege. Now, you might say to yourself, well, a lawyer is clearly involved here, right? The client prepared the report, and there's no question that this report ultimately went to the lawyer. So why shouldn't it be solicitor-client privilege? And the answer is very simple. Solicitor-client privilege is incredibly powerful, but it has to be restrained. And the reason should be obvious. As much as we love legal advice privilege, we have to remember that privileges themselves are really bad things for the court. They deprive the courts of the best information possible, and therefore, as powerful as legal advice privilege is, it is only going to be applied when it applies to its conforming rationale, which is that it is allowing the client to access legal advice in some way or another. And where it is not doing that, we're not going to clothe it with privilege simply because a lawyer was involved. And if you think about it, it has to be that way. If we didn't do that, lawyers would be involved in everything. We would just simply hire a lawyer. It'd be great for lawyers. Law students listening to this are going, yes, great idea. Lawyers would be involved in everything. We'd let them get their hands on every single piece of information, and effectively you'd be using them as ways of keeping things secret. It cannot be that way. The privilege has to be narrow to ensure that when you are using an expert to get a financial advice, that is not what privilege is designed to protect. So we have to construe that exception, that representative, that third-party intermediary thing narrowly. And that's exactly what happened in Redhead. But I won't lie to you, these situations are very complex because it's not always easy to pull apart when a lawyer is simply there to look at information that's been prepared and when the expert is really providing information that is allowing the lawyer to provide legal advice to the client. And this will be difficult, and essentially Redhead shows how difficult this can be. The accountants are hired to help with financial information. And really, they assist in complex transactions by providing the financial reports, but also by providing advice about the financial ramifications, as opposed to the legal ones, of a particular transaction. So the question is whether the accountant's work is privileged. We know what the lawyer says to the client is privileged, but what about what the accountant says to the lawyer or to the client? And I remind you that in some cases you might have a valid litigation privilege, not in this particular one, but don't get confused by that. Whether or not litigation privilege applies is a completely separate question. So here's what the Saskatchewan Court of Appeal said, and what I think is a very, very sensible opinion. Number one, we have to remember that accountant communications are not privileged. There's no such thing as accountant-client privilege. And essentially, it depends upon the function of the third party. And for reasons I'm about to show you, or actually I've already adverted to, if it's not essential to the solicitor-client relationship, that's the key. How essential is this input to this relationship? If it's essential, then it will be privileged. If it's a channel of communication, well, that's like the secretary or courier, a messenger, like the translator, or here's the exception that might apply here, assembling information to make it understandable. And the example I often give to my students is I say, well, the client wants to make a real estate purchase, and they're not sure they have enough money and can do it effectively, and they provide their expert, their accountant, say, can you provide all this information to my lawyer? Create a balance sheet financial report that allows the lawyer to assess whether or not the transaction can be completed. That might not be the best example because it's not clear that there's going to be legal advice premised on that, but you get the idea. The question is whether or not the expert is compiling or putting information together in a way that makes it understandable to the lawyer. But the key is opinion. And the court really bound in on opinion and said, look, where the expert is providing opinion of a financial nature, then it's not designed to be essential to the solicitor-client relationship, even though, here's where you've got to be careful, even though it helps the lawyer make a decision, right? It doesn't mean that the expert's opinion is actually privileged because the expert is providing a financial opinion, and that is not essential to the communication between the lawyer and the client. And that's what people get confused about. They sometimes say, well, without the expert, the lawyer could not have concluded the transaction. But that's not the standard by which we hold it. We cannot just say that the lawyer being involved to provide ultimate legal advice makes the expert's opinion privileged. And another good example, if you're thinking about it, is a psychiatrist. It's no different. If you send a client to a psychiatrist and the psychiatrist then provides a detailed psychological opinion, well, that opinion may help the lawyer make a decision about what to do with the client, But that doesn't make it a solicitor-client privileged communication. The psychiatrist's opinion may well be protected by litigation privilege, and probably is. I haven't given the hypothetical facts here, but it doesn't make it privileged. And just to finish up, I want to talk about one particular quote that the Saskatchewan Court of Appeal gave that I think was really important. The clients trying to have this communication excluded, it was ultimately admitted because the accountant gave an opinion on the financial merits of the transaction, said, look, the lawyer's driving the bus. Everyone's traveling to the same transactional destination, so ultimately the lawyer is the one giving the opinion on the legality of the transaction, so therefore everything provided to the lawyer is protected. And the Court of Appeal said no. They recognize that approaching it this way, as attractive as it might be for lawyers, this is what's going to be argued every time. You're always going to say that the function of the third party is to assist and facilitate, but that's not good enough. Assisting and facilitating is not enough because a broad definition would allow people to assert privilege in situations when it shouldn't be available. We simply cannot forget that the solicitor-client privilege, as important as it is, deprives the court of information. And the case offers us a good reminder that the key to solicitor-client privilege is not the presence of a lawyer in the communication. That's important, but it is not the essence. It's the function of the particular communication. If that particular communication is not to obtain legal advice, then simply it is not protected. And that's why as soon as the accountant starts to provide an opinion about the financial implications, that opinion is not protected by solicitor-client privilege because it is not a communication from the client to the lawyer to obtain legal advice. Really interesting little point, but an important one we need to remember in trying to assess whether legal advice privilege applies. I hope that was of interest to you, and have a great day.
To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.